All right, everybody, it's 10 o'clock. We're going to get started. We had a bunch of people on the webinar this morning, and probably a few more will be joining soon enough. So we're going to be talking about the 2022 NABOR contract changes today. Yeah, my name is Sam Saad. I'm an attorney in Southwest Florida, and the NABOR contract is predominantly used in, of course, Collier County and Southern Lee County. So the contract changes are not a lot of them. This presentation is going to run maybe half an hour. We're going to talk about the changes and I'll take questions. You can put your questions in the chat or just unmute yourself and shout them out. We're streaming live to Facebook. So if you are watching on Facebook, you can get your comments and I'll respond to them after the webinar is over. So the contract, of course, we've got the residential improved property contract, the vacant land contract, the as-is contract, and then the listing agreements and disclosures. So I'm going to talk primarily about the residential improved contract. The changes apply equally to the vacant land and the as-is, unless I say otherwise. I want to get started right away, so we're going to dive right in and talk about the contract. Right up front in the first paragraph of the contract, we made a few changes to what's included in the definition of property and personal property. So we clarified the home automation, smart home components are included in the contract. We also added electronic vehicle charging equipment, including all operational components, are included in this contract now. So if you've got a Tesla charger, that transfers with the property. And we clarified that access codes, along with the keys, fobs, and other access devices to community property, all need to transfer at closing. There's been a lot of questions about what components, what parts of the home transfer. So we're just trying to clarify that if it goes to the running of the home or access to the home, it transfers with the property. The next section that we made changes to was the financing section. We did not make any substantive changes to the financing section, but what we did is we reformatted it so that it's easier to read. Now all the changes are highlighted along the left margin of your contract. I'm sorry, not the changes, the choices. You can check cash, financing, or seller financing. And it's just along the margin to make it clearer, easier to read for you. And we put these boxes here all on one line. Same with these boxes. They used to be on two lines. Next up in the inspection section. So when you go to make inspections under the NABOR contract, you used to have three choices on the standard contract. You could check for inspections, a due diligence inspection, which makes the sales contract an as-is contract, or you could waive inspections. Well, it never made sense to us on the committee why you would have a due diligence inspection when you could just use the as-is contract. So now, for those of you that like to make due diligence offers, as-is offers, you would use the as-is contract, not the regular contract, because the regular contract no longer provides for an as-is option. However, if you are a seller, for example, and you're receiving an offer that has inspections and you wanted it to be due diligence as-is contract, NABOR still provides the as-is due diligence inspection addendum. So you can always attach that addendum to this contract, and you can turn a regular contract into an as-is contract with the addendum by checking the appropriate box on the last page of the contract. And I don't put line numbers on my slides on purpose because the line numbers change depending on the format of the form, the form provider. So if I gave you line numbers now, they wouldn't match the numbers that are in the actual contract. So I took those out. However, of course, all of the NABOR contracts are properly numbered. The next up under survey and title policy standards in standard B, it used to be that the seller had to provide a complete copy of the survey and owner's policy in the seller's possession. Now it's just any title policy in the seller's possession that they may have. And we no longer, this is a kind of a big change for a lot of people, we no longer charge the seller $150 if they, for whatever reason, cannot produce their title insurance policy. So the old $150 charge is gone. The seller's got to provide what they have. Okay, moving right along. Up next in the contract, the survey objections have changed. It used to be that you had to be have a survey certified to the seller. Now it's just a survey that the seller has in their possession. We say provided by the seller. And we clarified here that the improvements include the property or the real property because they're defined separately on page 1 of the contract. And we added a new survey objection that says the real property does not meet the applicable development standards of the local government having jurisdiction over the real property and is otherwise deemed legally non-conforming. So what does that mean? That means that if the property, for example, in Old Naples is too small to build on, that would be a survey objection now. As you know, for example, Old Naples has got some of those old lots that are 33 and a third foot wide, but you need 75 feet as the minimum frontage to build in Old Naples. So you would need 3 lots to build as a minimum because 2 lots would only be 66 2/3. We've seen a couple of times where people can't make improvements to the property they want in the city of Naples because of the lot size, and there was no remedy in the contract to object to that, and now there is. So if the lot is illegal lot for whatever reason, that's a survey objection now. Debbie is asking, has the timeline of events been updated to match the standard contract? Debbie, yes, it has. Dorazelle is asking for the contract to print. Dorazelle, you can get the contract to print off of your forms provider website, but they are they should all match what I have in here now. We updated with everybody. Let's see here. So the next change is the insurance claim section. So the seller is always made a representation that they're unaware of past claims, which would increase the cost or restrict the availability of insurance. Well, now the seller has a continuing obligation to disclose any insurance claims filed or to be filed. So the seller has a second affirmative duty that has to be taken where they have to tell us about insurance claims on the property and any claims they intend to file. And they have to keep the buyer updated. Up next in the community investigation section, this is standard D1 C, I believe is where it is, that we added ambient noise level as a something that the buyer needs to investigate prior to contracting. This is at the request of the Naples Airport. They wanted a much more broad language about airport noise. The committee settled on just adding that ambient noise level is something that the buyer needs to investigate in the community that they're buying prior to contracting. So they wouldn't be able to get out of the contract if, for example, there were planes flying overhead the whole time. Moving right along, the seller's maintenance obligation section. So we had a bunch of problems with sellers who were incurring violations of in their association during the contract period, during the pendency of the contract. So we added whether existing prior to or after the effective date, seller's maintenance obligation shall include curing any and all violations documented by the association against the property prior to the closing date. So if the seller gets noticed for a violation, they now have to cure the violation prior to the closing date. If they do not cure the violation, and if there are fines accruing, then the 200% cost, including post-closing fines, all get escrowed and get paid after closing. So if, for example, you go to closing and it turns out that on the estoppel, the bushes haven't been properly maintained, or the garage is the wrong color, or the driveway needs to be pressure washed, or the roof tiles are out of sorts, either because they're cracked or the new ones that were replaced don't match, and those are association violations. There would be an escrow for the estimated fines, including possible daily fines, against the seller for fixing those problems, and that all now gets a part of the 200% escrow for post-closing issues. And then we clarified, following up on that, in the seller's expenses, the seller will pay for the utility estoppel fees and outstanding bill balances due to the utility services up to the closing date. That was always assumed, but never actually in the contract. Now it's in the contract. And they have to pay any, again, outstanding balances or fines due to the association at the closing table. So that'll be on the closing statement from now on. Typically, it's on the estoppel. Now it's clear any fines due have to be paid. Additionally, the sellers has always been responsible, but we clarified, for reasonable fees to the buyer's attorney or closing agent for handling FERPTA issues. So if your FERPTA costs have always been a seller expense, but now it's clear, even though it's a buyer responsibility to deal with FERPTA, it's a seller expense. And then the seller also has to provide an assignment of insurance and service contracts that the buyer wants at closing. This is kind of a big deal with FEMA flood policies and other insurance policies that are assumable, given the fact that insurance rates are going up so much. We wanted to clarify that these contracts that are assignable, which can be assigned at the buyer's option, the seller's got to cooperate. Up next, this has been kind of a controversial change, and I'll mention first, before I get into the controversial change, you'll notice on these slides where you see like these capital A's and the word association in blue. I'll get to it at the end. It's the last change in the contract, but we actually changed the contract so it's easier to read. No longer will it say homeowner association / co-op / condominium. We just defined association in the contract, and it makes it say association throughout the contract. Minor change, but makes it easier to read for you and your customer. Okay, so it used to be the case that if the buyer was not approved by the closing date, that the buyer or seller could terminate the contract. But we noticed one of the problems that the committee noticed is a lot of times the reason that the association hasn't completed the approval process by the closing date was the buyer was waiting to make application to the association. Well, the buyer has 10 days per contract to make application. They were waiting till the inspection periods were over. They were waiting till they were approved by the lender, and people weren't getting their association applications in a timely fashion. So now, in order for the buyer to terminate, they must, their right to terminate is conditioned upon the buyer timely submitting application to the association for approval. If they don't, then they cannot terminate and their deposit's going to be at risk. So it's very important to make that association application within 10 days of contracting. That's going to be a big deal going forward, and the committee is debating changes to that already. The seller also has a limitation on their right to terminate. The seller used to be able to terminate if the association approval wasn't done by the closing date. But if the reason that the association has not approved has not approved the application yet is because the seller has violations, in past due balances, we will now coordinate with the association. Your closing agents will have to coordinate with the association, and those fines will have to be paid at closing, like we discussed earlier. But the seller will not be able to terminate if for some reason the application has not been approved because of the seller's failure to maintain their association obligations. So that's going to be a big change. No longer automatic termination on the closing date. Let's see what questions we have. Stephanie is asking, does the seller need to know claims prior to ownership? And what does number 13 do? Stephanie, on that one, the seller would need to disclose any claims that they are aware of. So if there were claims from the past, but the seller, for whatever reason, didn't get insurance and didn't know there were past claims, then obviously if the seller doesn't know, they can't be held liable for it. And number 13 just means that number 13, I believe you're referring to, is this assignment of insurance and service contracts, which the buyer elects to assume at closing. The buyer has the right to assume the insurance contracts that are cover the property, and the seller has to cooperate. Okay. So the next thing that we changed was we clarified that the seller may terminate the contract and all deposits made shall be paid to the seller as liquidated damages. So what does this mean? When the buyer is in breach of contract and does not perform, it said before that the deposit goes to the seller. We all kind of knew that the deposit goes to the seller if the buyer breaches, but the contract never actually said that the seller can terminate the contract and keep the deposit, which led to some open legal questions about whether the contract was actually terminated. Now it's clear in the contract that the seller may terminate and all deposits made go to the seller as liquidated damages when the buyer breaches. Okay, the next change, this is going to be one that affects all of you that everyone's been talking about, big change, no texting. You can no longer text your notice in the contract. You have to email it, mail it, or personal delivery notices to the other side from now on. No more texting is allowed to, for example, waive the finance contingency or waive inspections. You would have to put it in writing and email it. Excuse me. So this is kind of an important change, I think, for people to understand that the texting, you can always text me and you can always text each other, but for purposes of official notice, then you would not text, you would email or mail. Of course, we don't use US mail for hardly anything anymore. So you would email or fax the notices to the other side. Next up, so I mentioned it before, in the last line of the contract, we have defined association, and that just means all homeowner associations, condo associations, and cooperatives that are subject to the contract, which have authority over the property. We just refer to them as association in the contract for simplicity of reference. So the next major change in the contract is no more lines for the addendum, for the addenda. If the following addenda, if attached hereto, are checked, then they would be incorporated into the contract. So you have to do two things, but you always had to do two things. You used to have to write in the name of the addenda, the addendum you want to use, and then you would attach the paper to the contract. Now you just have to check the box and attach the paper to the contract. So make sure that you check the correct boxes and attach the correct forms. Obviously, if you check other, you would still need to talk to your favorite closing attorney and have whatever you needed drafted, because as realtors should not be independently drafting contract language. Okay, before I move on, does anybody have any questions about the sales contract or the as-is contract? All these changes are the same in both contracts. Let's see. I don't see any hands going up. Okay, then let's keep moving. So the listing contract, we didn't make too many changes to the listing contract. It was changed to match the sales contract. One thing we did add to the listing contract is we added attorney's fee provision. I know it's very rare that a listing agent would sue a seller, for example, a commission. But if you were to sue a seller for a commission, now the prevailing party in litigation gets their attorney's fees paid by the losing party, to give you more protection in the case you have sellers who, for whatever reason, just want to breach their listing agreement and to waste your time and your money. We did also add checkboxes to the listing agreement. So again, if you attach the addendum to the listing contract to the contract and you check the appropriate box, then it would serve to attach the addenda to the listing contract. Okay. Next up, let's talk about the addenda and the disclosures. There were some minor changes. On the backup contract, we added an advisory that the parties seek legal counsel. On the backup contract, you've got to be very careful that you don't obligate your seller to multiple contracts at once if they were to accept multiple backup offers. Of course, during the pandemic, this was much more of a problem than it is now, but we're still seeing backups coming in, and you want to make sure that you number and label the backups. So get with me if you have any questions on your backup offers. On post-closing occupancy, there had been an issue where buyers are wanting to put things in the garage, for example, during the pendency of the post-closing occupancy, and sellers were not giving access to the property, even though the closing had occurred and property is technically the buyer's. So we added a checkbox on the post-closing occupancy form that allows, if the seller and buyer agree, for the storing of personal items after closing. And then on the seller's right to make backup contracts, the primary contract, we made a change that subjects the contract to the MLS rules regarding active versus pending listings. And then on the inspection election notice, we added an advisory that you should not use that form with an as-is contract. This is kind of an important point because I see a lot of realtors will use an as-is contract, and then they'll use the inspection notice and buyer's inspection notice and seller's response form. Well, the problem is if you use the inspection notice form and you don't make a separate amendment to your contract, your buyer has no remedies should the seller fail to complete the repairs of the defective items prior to closing. There is no 200% in the as-is contract for defective inspection items because it's an as-is contract. It doesn't contemplate defective inspection items. You actually have to put that on an amendment to contract. So don't use the inspection election notice form on as-is contracts. We need a separate amendment that I will draft for you. Up next, on the insurance disclosure, previously this was just for flood insurance, but insurance has become such a problem in Florida, although the legislature just met in special session and is fixing the insurance crisis in Florida. We did update the insurance disclosure to be more generic and include all insurances, not just flood insurance. So you, in your practice, you really need to use this language, this disclosure, and protect yourself and your broker from the crazy insurance market that is the Florida insurance market. Okay. Up next is the new HighRise Disclosure. So you probably are aware that the Surfside collapse on the east coast of Florida has caused some major problems. A lot of people lost their lives, and it was a very terrible situation. But in true Florida fashion, the legislature responded fairly quickly and passed a consumer protection and safety measure. Basically, every building that's 3 stories or more in Florida is going to have to be inspected for structural integrity. If your building is over 30 years old, if you're within 3 miles of the coast, which of course all of our 3-story plus towers in Collier County are within 3 miles of the coast, then it's 25 years or older. You must do the structural milestone inspection and the structural integrity reserve account study. So basically, all these condo towers that are more than 25 years old have to be inspected for structural issues, and a structural integrity reserve account study has to be completed showing that the association can afford the structural repairs that are invariably going to come as these buildings age. This is going to be a big deal for condominium dwellers because of the associations. Right now, there just aren't enough engineers and architects to do all these inspections, so they can charge whatever they want. It's very expensive to get these inspections done, and then to complete the maintenance and maintain the reserve accounts is going to be an additional added expense for condominium owners that you're just going to have to deal with as you go through your sales process for condominiums. And with that, does anybody have any questions? You feel free to unmute yourself and shout them out, or type it into the chat. Any questions? Let's see. One second, Vania. Stephanie is asking HighRise Disclosure time frame after have these done. So they've got the inspection. The statute is passed, and the HighRise inspections have to be done by the end of 2024. Okay. Other questions? Linda is asking, will this be a problem with getting a mortgage if the building has not been done? Linda, this is already a problem for mortgages. Fannie Mae and Freddie Mac have new condo questionnaires they want filled out by the association. A lot of associations are refusing to fill them out or are unable to complete them because they are behind on their reserve accounts. So I would say this is already a problem. Okay, yes, Vanya?
Yes, I just wanted to find out in that structural report that they need, is there a time limit as to how old it needs to be? Is it like a yearly, or how old for them to accept a report if they have done it?
So the report has to be completed immediately by the end of 2024 for the initial one, and then every 10 years thereafter.
Okay.
So you'll see and they are talking about including these documents, these reports in the required condominium documents. So you should expect in the near future that everyone is going to have to see these reports and post them. This is going to be a big deal. Other questions? Okay. Debbie is asking, can you confirm if the first level is open parking and 2 floors above for living, will this be considered 3 floors? Yes, Debbie, it's 3 stories. So 3 stories tall or higher. So you would be, your 2 floors of parking would be part of the stories. Yolanda, yes, you can get a copy. This is being streamed live on Facebook, so it'll be posted to my Facebook page, and it'll be on YouTube this afternoon. Other questions? All right, everybody. Thank you very much for your time. Oh, wait. Guy's asking where the HighRise disclosure is found in your forms files, Guy. It's with all the other contract documents. So I said we'd be a half hour. It's 10:30. Thank you all very much. I really appreciate your time today. You can call me, text me, email me, smoke signals, whatever you need. Just let me know. And I'm happy to help you all with your contracting needs. I'll talk to you all soon.